These are appeals in the matter of Mammedov and Nisar and others and the Home Department.
Yes, Mr. Malik.
Milady, my lords. I appear for the appellants this morning with Mr. Gaja, who drafted the grounds of appeal and skeleton argument for this court, and Mr. Jamali, who drafted the grounds of judicial review and represented the appellants below. My then friend Mr. Brown appears for the Secretary of State.
Yes. Did both your juniors appear in both cases, or one in one and one in the other?
Both in both cases, my lord.
Yes.
Lady and lords, these two appeals have been linked to her together because there is common issues as to the costs of the judicial review claims at the Upper Tribunal. The appellants have 5 things in common. First, their applications for entry clearance were refused by the Secretary of State. Second, they challenged those refusals, resulting in the Secretary of State agreeing to make fresh decisions and confirming doing so by a particular date, absent special circumstances. Third,
Just a minute, if you're dictating points, I want to write them down.
That's all 1 point.
that is the second point, yes.
Yes.
Third, despite the reminders by the appellants, the Secretary of State failed to issue fresh decisions by that particular date, or to provide any update to the appellants. Fourth, the appellants issued judicial review claims and shortly thereafter, the Secretary of State made fresh decisions and the claims were compromised by consent. And fifth, in each case, the Upper Tribunal decided to make no order as to costs. I shall seek to persuade the court that the Upper Tribunal erred in law in each case, and that the appropriate order is one that requires the Secretary of State to pay the appellant's costs. So subject to any observations, what I propose to do is to take you to 3 key authorities on the subject and make some general submissions on the law. I will then, my lady and lords, take you to the key documents in each appeal, including the Upper Tribunal's decisions in turn, and will make submissions on the facts, including the submissions as to why the Upper Tribunal's decisions are wrong in law.
Would you mind very much doing it the other way around? Speaking for myself, possibly also for my colleagues, I'd like to see the the facts
Excellent.
first,
Very well.
and then you can. And could you start with the Nisar case and then Mammedov?
Absolutely. I'll do that. So Nisar case first. Miss Nisar is a citizen of Pakistan, and along with her children, she made an application for entry clearance as a visitor on 8th of June 2022. The application is refused by the Secretary of State on 29th of August 2022. And may I show you that decision? If you have the supplementary bundle in Nisar, that decision appears at page 80.
Sorry, page.
Page 80.
Thank you.
So this is the decision of 29th of August 2022. And you'll see that by that decision, the application is refused on the basis that the requirements of the immigration rules are not met. In short, the decision maker took the view that the appellant was not a genuine visitor. That decision, my lady, my lords, is challenged by the appellant by way of a pre-action protocol letter. That letter was sent on 5th of September 2022. And the letter starts at page 86 of the bundle. This is the supplementary bundle.
Yeah.
If you look at page 90, you'll see that the appellant asked the Secretary of State to withdraw the decision within 14 days. And it was said that the appellant will consider challenging that decision without further notice if that did not happen. The Secretary of State accepted that her decision was a poor decision and agreed to reconsider it on 15th of September 2022. The letter by which the Secretary of State agreed to do so is at page 94 of this bundle. You'll see from the second paragraph, the Secretary of State says that I have reviewed the decision. The decision is withdrawn. We will be in contact with you in due course. Reconsiderations are taking at least 3 months. The Secretary of State reconsiders the decision and issues a fresh refusal on 3rd of November 2022. That, again, with respect, is a patently poor decision. You have that decision at page 100 of the bundle. And my lady and my lords will see that this decision is more or less in the same terms as the first decision. The decision maker again concludes that the requirements of the rules are not met and the appellant is not a genuine visitor. The second decision is challenged by a second pre-action protocol letter. And that letter is sent on 21st of November 2022. That letter starts at page 105 of this bundle. If you look at the submissions at page 168 and 108 and 109, the appellant explains why that decision is equally flawed. Last paragraph at page 109, the appellant invites the Secretary of State to withdraw the decision within 14 days and said that they would apply for judicial review without further notice in the event of a default. Secretary of State accepted that her second decision was also a poor decision. And agreed to reconsider the matter again. That was communicated by way of a letter dated 23rd of February 2023. And that letter is at page 151 of the bundle.
Sorry, second agreement to reconsider, 23rd February 2023.
Yes, so if you go to page 151, you'll see a consent order. So what happened following the pre-action protocol letter that I've shown you was that the Secretary of State initially resisted the claim. Judicial review proceedings were issued,
Yes.
and there was this consent order. And by way of this consent order, my apologies, I refer to that as a letter that is sealed on 23rd of February 2023. The decision maker agreed to reconsider the second decision.
And by consent, the respondents agreed to pay the costs.
Yes. So this is the second decision, second agreement to reconsider. The Secretary of State reconsiders the application and produces another poor decision. The third decision is dated 12th of April 2023.
Sorry, 12th of April, did you say?
Yes, 12th of April 2023.
Thank you.
And it is at page 152 of the bundle. You'll see again that this is a decision more or less in the same terms as the first two decisions. The decision maker again says that the requirements of the rules are not met and the appellant is not a genuine visitor. The appellant challenges this decision by a third pre-action protocol letter. And that letter was sent on 18th of April 2023. And you have that letter at starting at page 156. If you look at page 159, 160 and 161, the appellant explains again why the decision is a poor decision. Again, invites the Secretary of State to withdraw it, saying that they would apply for judicial review in the event of a default. Secretary of State accepts again that her third decision was a poor decision and agrees to reconsider it again. and she did so by way of a letter dated 2nd of May 2023, and you have that letter at page 164 of the bundle.
When you say, as you have several times, that the Secretary of State accepted it was a poor decision, what are the words that you're relying on in the letter?
If you look at page 165, the Secretary of State has reviewed the decision and will now proceed to reconsider the matter in the light of the representations you have made. And of course, the Secretary of State does not say in terms that my decision is a poor decision, but the submissions, representations are made explaining that this is a poor decision. The Secretary of State concedes that that is the case. You'll hear from a learned friend, but learned friend will not seek to defend the decisions that have been considered. The decisions were plainly unsustainable. Of course, there's no need for the court to look at the merits of those decisions, save as to the last decision, perhaps.
But all we see in each of these letters is we'll proceed to reconsider in the light of the representations you have made. And reconsideration is a standard procedure. Can't remember whether it's under the rules or Home Office internal guidance, and it doesn't matter. But as my Lord is hinting, the letter doesn't say we accept every point you've made in your PAP letter.
And that surely is the case. Milady and my lords have seen pre-action responses and consent orders in many other cases.
Yeah.
They don't of course record that there is a sort of formal concession, but the point is that the decision is withdrawn and the Secretary of State agrees to reconsider the decision. The appellant, and this is the sort of ultimate submission that I will make, is at that point on a merry-go-round.
Yes.
That really is the point that matters to the submissions that I'll make on costs. The Secretary of State agrees to reconsider the matter again. This is the third agreement to reconsider, and the Secretary of State produces a fourth refusal. You have that refusal at page 167. It's dated 16th of June 2023. And Milady and my lords will see that this is again in more or less the same terms as the first three decisions. The decision maker again says that the appellant is not a genuine visitor and that the requirements of the rules are not met. And the appellant challenges the fourth decision by way of a fourth pre-action protocol letter. That letter is dated 23rd of June 2023 and starts at page 171. The submissions are made at pages 174, 175, and 176. And again, submission is made that this is again a poor decision. Look at page 7. Secretary of State is making the same decisions again. It's the fourth refusal on the same application. The decision that in substance is no different. Again, it's explained why that decision is simply unsustainable. And the Secretary of State is agreed to reconsider the matter. But what is relevant, if you look at, for the present purposes, if you look at the heading conduct of the respondent just above paragraph 13,
Which page?
sorry, page 175. So you have seen paragraph 7, where a point is made that, well, this is the fourth board decision. And then you have a heading conduct of the respondent, and a point is made that they're making factually wrong decisions again and again. They have refused the applications on multiple occasions. And that is again a failure to consider the matter. What is said in the decision is demonstratively flawed. A point is made this time that there are children, this is paragraph 16 at page 176. So the idea was for children and mother to visit the UK. Father would stay in Pakistan. The children are in full-time education.
But I think I saw that in some of the earlier PAPs as well, didn't I?
Precisely.
About the children.
About the children, yes. But what is different in this PAP is that there is an express complaint as to the conduct of the respondent, that they are making repeated decisions. This is the fourth decision. The Secretary of State agrees to reconsider that decision again.
In your favour, it can be said that on page 180, there's an express acknowledgement of the challenges you've raised, and as such, comprehensive steps have been taken to evaluate the matter. So this time it's a bit different. It's better from your point of view.
I'm very grateful. Yes, there is. I mean, I'll show you the last letter. I mean, which makes the point, of course, better. But I'm very grateful to that, my friend. I'm very grateful to Malord. So page 179, you have the letter of 5th of July 2023. Again, another round of merry-go-round again. The Secretary of State says that we acknowledge this page 180. I'm very grateful. And so by that date, I mean, this is really relevant. On 5th of July, by 5th of July, the Secretary of State has already taken comprehensive steps to evaluate the matter. And the intention is to provide a meaningful remedy. The Secretary of State aims to issue a reconsidered decision by 5th of October 2023, barring any complexities. So,
Bearing any complexities.
bearing, yes, very good. Fine, bearing any
Yes.
yes. 5th of October 2023 is the date by which the Secretary of State says, well, I aim to make a decision. The appellant says that, the appellant writes back saying that, well, this is not acceptable. Look at page 182. There is a letter, it's an email dated 7th of July 2023. The appellant makes the point that there's been 4 decisions, repeated failure to consider the evidence, and page 183, third paragraph, submission is made that the respondent is misusing the pre-action stage. Essentially making the same decisions, thereby sort of preventing the appellant to bring a judicial review challenge. The appellant makes the point that, well, there is no new evidence that I'm seeking to submit. You have all the evidence, you have the repeated explanations, and finally, the appellant makes the point that, well, you make the decision within 6 weeks, before 21st of August 2023. not only you make that decision, but also serve that decision by that date. If you don't accept that, then we will apply for judicial review, and we will rely, the appellant said, on your pattern of unlawful decisions that you have to then withdraw. The Secretary of State responds on 25th of July 2023, and you have that decision at page 186. Context is really important. The appellant is saying to the respondent that in history of unlawful decision making, you're misusing the pre-action stage. If you don't make a decision by this particular date, we will go for judicial review. So this is a clear notice. The respondent's response is page 186, 25th of July 2023. The language couldn't be clearer. This is point 5 of the letter at page 186. Thank you for your pre-action protocol letter regarding the delay in processing your client's visit visa application. So I do invite my lady and lords to take a note of that sentence. A point that the Upper Tribunal made against Ms. Nisar is that there wasn't compliance with the pre-action protocol. This is the pre-action protocol regarding the delay that was sent, which was responded to by the Secretary of State. In response to that pre-action protocol letter, Secretary of State says that the entry clearance officer have confirmed, not indicated, not an aim, confirmed that a decision regarding your client's visa application will be made by 21st of August 2023, absent special circumstances. So pre-action letter is clearly sent. This is the response confirming in black and white that unless there are special circumstances, we will make a decision by 21st of August 2023. Of course, the court knows that in immigration jurisdiction, it's well settled that a decision is not made until it is served. Lord, this has been knows about a case that was heard earlier this year. It was decided a few weeks ago, but it's uncontroversial that a decision in draft is not a decision at all. So you have to serve the decision before it is effective. So although this is a very clear confirmation that a decision will be made by 21st of August, because of what had happened previously, the appellant sends another reminder to the Secretary of State. And that reminder is sent on 20...
Sorry to interrupt, Mr. Merrick. Before we leave the letter of the 25th of July, is the first paragraph, page 187, is that just standard mechanical wording? It doesn't seem to have anything to do with address for service of the court document.
That is a standard wording, yes.
So that the Secretary of State is providing the remedy of a promise qualified by special circumstances.
Yes.
In response to a complaint of delay, unreasonable, unlawful delay in deciding the issue. Is that
That's the
analysis?
Yes. Yes.
Sufficient remedies being provided for the delay. Okay, right.
And then, my Lord, as my Lord the Vice President has pointed out, the Secretary of State says that, well, this is sufficient remedy to the complaint that I've shown you, delay and repeated unlawful decisions. So, my But because of what has happened,
Right, just
yes,
so just picking up what my lord said, I was saying therefore the pre-action protocol now considered to be concluded at page 187. So it's the Secretary of State's position, therefore there is no longer an active pre-action protocol letter because it's deemed to have been
yes, because
said that you can no longer rely on that.
yes, because I have made a promise
Yes.
that I will make a decision by 21st of August 2023, absent special circumstances. Absolutely. So because what the Secretary of State has done previously, the appellant suspects that the same thing would happen again. So she sends a reminder to the Secretary of State on that you have at page 188. So this is 25th of July 2023. As soon as that letter is received, the appellant says that, well, you are aware of how poorly the respondent has dealt with this matter. You have now confirmed that the decision will be made by 21st of August 2023, absent special circumstances. You must serve the decision by that date. If there are any special circumstances, you have a duty to confirm that in writing, provide some evidence, and then a very clear notice that if you fail to act, we will act without further notice. We will claim costs for doing so. It's the fourth challenge, fourth unlawful decision, poorly drafted refusals, and that we may also seek damages. The Secretary of State failed to comply with the promise that she made. She makes no decision, despite this reminder, by 21st of August 2023. She sends no letter to the appellant explaining that there are special circumstances and that the decision would be made by a new date. There is complete silence. The appellant waits patiently until 21st of August 2023 and then issues the judicial review claim on the next day, 22nd of August 2023, exactly what the appellant said they would do. So if you now go to the co-bundle, you'll see judicial review claim form at page 86. This is issued, you'll see, on 22nd of August 2023, a day after, the day after the promised date. If you look at the grounds of judicial review, page 106, you will see that this isn't simply a complaint about the ongoing delay in a decision. So it isn't a sort of paradigm case where an application is made to the Secretary of State, the Secretary of State fails to make a decision, and a claim is issued saying that, well, you haven't made a decision and that delay is unlawful. The complaint here, if you look at paragraphs 1 and 2, is that there have been repeated poor, factually incorrect decisions, despite the fact that the applicant's circumstances were quite clear. The matter has now been pending over 14 months. And if you look at the actual pleadings, you'll see that all relevant letters are addressed, and a submission is made that, well, you said that you will make a decision by 21st of August. You failed to make to comply with that promise. That is the submission that is made at page 117,
Yes.
paragraph
Can
30.4.
can we just go back to 186?
Yes.
You recite you described as the merry-go-round. You say the respondent has repeatedly made full and factually incorrect decisions. The decision is challenged. The respondent withdraws the decision and agrees to reconsider. That's happened several times, 14 months. The applicants submit that such conduct by the Home Office arguably amounts to an abusive process. Why is it an abusive process? And you could, each time there's a refusal on reconsideration, you could then bring a judicial review claim. Why is it an abusive process? You may say it illustrates a closed mind. You may say it's wrong on the merits. You keep bringing the claim.
Yeah.
They use the reconsideration. Tactic, tool in the toolbox, whatever it is. Each time the answer is no.
Yes. Well, Lord, you're absolutely right. I would not have pleaded an abuse of process ground, but in fairness to Mr. Jamali, if you look at the actual grounds of judicial review, he did not plead an abuse of process ground.
Yeah, I'm not saying this is improper or being overcritical. I'm just asking why the phrase abusive process.
Yeah, I think what, just in fairness to Mr. Jamali, he was setting the scene and making a point that, well, the pre-action protocol stage is being abused, but that isn't a ground. And I agree, my lord, that this isn't a case where one can build an argument that there is an abuse of process. So,
Okay.
right, no. I agree, my lord, with what you said.
All right. Now you were taking us on to
Yes.
which page?
Yes. So you'll see, of course, that the history is set out at length. Each pre-action letter and response and judicial review claim is set out, and then various grounds are advanced. A point is made that if you look at page 115 of the bundle, you see sorry, my apologies. So 114, 115, you'll see references to various authorities.
Yes.
Look at page 116. The appellant makes the point that this isn't an FH style case. FH is a well-known authority of the administrative court where the Secretary of State wasn't making decisions on fresh claims. The appellant said that the continued delay was unlawful. Mr. Justice Golden said that, well, you can only claim, you can only bring a judicial review claim if the delay is so excessive that it's witness-free irrational. The appellant makes the point very clearly that this isn't that case. This is a case where there has been a history of poor and factually flawed decisions. Nothing has changed. I have complied with the pre-action protocol. The respondent's approach undermines the scheme of the pre-action protocol. And then if you wish to see the real point that is made in the pleadings, this is paragraphs 30.3 and 30.4. The respondent has failed to follow through the undertaking that a decision would be made by 21st of August 2023. The respondent expressly agreed to conclude the matter by 21st of August 2023, but has not failed to follow through. There are no special circumstances, and that is the reason the delay is unlawful.
It's being put slightly differently there from the way that you've been putting it this morning, is it? It seems to me, anyway, the overall complaint is one of unreasonable delay, and the fact of a promise having been made and then not met is being used as some evidence of that, whereas you're making a more hard-edged point that against, it's subtly different, but I think it is different, that against the background, that promise should have been, it was unlawful not to make good on that promise. And that's the way it was put in the grounds.
Yes, ultimately, I'm not sure if this would matter, but my submission would be that both points that, my lord, you have identified are actually made in the pleadings, in the grounds. That there is an unlawful delay in the decision-making process. It's not an FH case, and there is a promise that the respondent has not complied with. The relief that is sought is at page 118, that the respondent makes the decision within 1 month or within a time frame that the tribunal considers reasonable. Although there is a reference to costs on indemnity basis, that isn't pursued, and costs are sought. Now, this judicial review claim is served on the Secretary of State. And the Secretary of State makes the 5th decision, again with respect to a 5th poor decision on the claim is issued on 22nd of August. It is served on 23rd of August, the day after. And after service of the claim, the Secretary of State makes the decision, the 5th decision, refusing the application for entry clearance on 5th occasion. Now, you do not have...
After that, the Secretary of State serves a decision. The decision, unknown to your side, had been made by somebody, presumably in the bowels of Marsham Street, but as you say, it's not effective until it's conveyed to the claimant.
Yes, so this court has said categorically that a decision is not a decision until it is served. This is what Section 4 of the Immigration Act 1971 requires. But, my lord, if you go to page 78 of the bundle, you'll see the respondent's submissions. And if you look at the chronology at page 80, this is the respondent's chronology. If you look at the last 2 entries, the claim is issued, it is served, and following the service on 23rd and 24th, the decision is served. It means it's made. That's
not in dispute.
Now, you don't have, my lord, the 5th decision in the bundle. That decision, as you'll see, was served on 23rd and 24th of August. She got it wrong again. She made the same decision, the same poor decision. And there was another round of merry-go-round, another pre-action protocol. And finally, on 7th of December 2023.
Sorry, what of December?
On 7th of December 2023, the appellant is granted entry clearance as a visitor. So these are the facts and documents in Nisar. Now, I will not take you to the Upper Tribunal's decision unless you want me to at this stage. So,
Sorry, I didn't, I may have missed something. So the JR is issued, the JR is served, the refusal is served. Was there then a consent
oh,
order?
yes, my apologies. I should have taken you to that document. It's page 84 of this bundle. So this is the consent order dated 20th of September 2023. The recitals record the fact that the claim is about the delay in reconsidering the decisions, the respondent making the decision and serving them on 23rd and 24th, and that made the judicial review claim academic. The claim is withdrawn, and you will see then agreed directions as to making cross submissions.
Thank you.
So I'll now show you the documents in Mammedov. I'll not show you the Upper Tribunal's decision now. What I want to do is to address you on the law,
Yes.
and then show you the Upper Tribunal's decision and make submissions in the light of the principles as to why the Upper Tribunal has got it wrong. So Mammedov, if you look at so Mr. Mammedov is a citizen of Turkmenistan. He applies for entry clearance as a visitor on 28th of August 2024. Secretary of State refuses the application on 18th of September 2024. If you have the supplementary bundle in the Mammedov appeal, you will see that decision at page 60. The application for entry clearance is refused. The decision maker takes the view that the requirements of the rules are not met and that Mr. Mammedov is not a genuine visitor. Mr. Mammedov challenges this decision by a pre-action protocol letter on 7th of November 2024. And you have that letter starting at page 65 of the bundle. If you look at the submissions, you see that the appellant explains why the decision is irrational. I mean, for example, if you look at paragraph 6, so in the application, the applicant stated that he wants to visit the UK to surprise the partner. The application is refused on the basis that there is no evidence from the partner. And the point is made that, well, that defeats the purpose of the surprise visit. And then further submissions are made why the decision is one that is unsustainable. Page 70, the appellant requires the Secretary of State to withdraw the decision and grant entry clearance, and says that if you fail to do so, we will issue a judicial review without further notice. The Secretary of State concedes the claim, or the proposed claim, on 14th of November 2024 and decides to withdraw the decision. That letter is at page 74 of the bundle. You'll see that the date of the letter at page 74 is 14th of October 2024. Well, that is obviously a typo. The true date is 14th of November 2024. Page 74, last paragraph, the Secretary of State decides to withdraw the decision, agrees to reconsider the application. Page 75, first paragraph. It said that they will now proceed to reconsider the matter in the light of the submissions, and that the aim is to reconsider the case within 3 months, absent special circumstances. Well, as promised, the Secretary of State reconsiders the application within 3 months and produces a fresh decision. That decision is equally flawed as the first decision. And the date of the decision is 12th of December 2024, page 77. You'll see that the terms of the decision are somewhat similar to the first decision. Again, point is made that that the applicant is not a genuine, the appellant is not a genuine visitor. The requirements of the rules are not met. This is the second decision. The appellant sends the second pre-action protocol letter. And that letter is sent on 13th of December 2024, the day after this decision is made. Page 83 is where the decision starts. And the point, again, if you look at the submissions, is that it's a complete failure to engage with the evidence and the submissions. The purpose of the trip is to surprise the girlfriend, the partner. If you then refuse the application on the basis that, well, there is no supporting evidence from the partner, that makes no sense. Further submissions are made that this decision is unsustainable. Page 88.
You say it's irrational. Why is it? You may not like it,
No.
but why is it irrational to say we don't believe you?
It's perfectly fine. So if the decision maker says that you say that your purpose of visiting the UK is to surprise your girlfriend, we don't believe you, that's a perfectly rational response. But what the Secretary of State cannot do is to simply fail to engage with the evidence, what the appellant said in the application, and produce a decision without engaging with that application, and simply saying that, well, there isn't a supporting letter from your girlfriend. So it's one thing to consider the evidence and reject it. It's quite another to just disregard it completely.
Is that what was said? I mean, there's a difference between not producing something from the girlfriend and not producing something about the girlfriend. I mean, I read it as being you haven't produced any evidence about the girlfriend. The stated reason, page 86A, paragraph 8A, did not demonstrate her legal status and her circumstances in the UK. But I mean, I may be misreading what the Secretary of State was saying.
Yes, not with respect. Sure that this is precisely what the Secretary of State was saying. Again, it matters not to the submission that I will make. But this is only one of the many points that are made in the pre-action protocol letters. The other point, if you look at page 87 of the bundle, is that it was said that the information provided did not demonstrate whether the permit This is the residence permit in Turkey was extended. Those documents were provided, and the complaint is that the documents were not considered. So various submissions are made, and the Secretary of State agrees to reconsider the decision again. The response to this pre-action protocol letter is dated 20th of December 2024. It's page 98 of the bundle. And you'll see that the Secretary of State acknowledged the challenges that you have raised. Again, by that date, the Secretary of State had taken, she says, comprehensive steps to evaluate the matter, and that she aims to issue a reconsidered decision within 3 months of the date of this response, and then by 20th of March 2025, absent special circumstances. Although there is the assurance that a decision would be made by 20th of March, the appellant sends a reminder to the Secretary of State on 16th of March 2025, before the deadline, and you have that reminder at page 103 of the bundle. This is just a reminder, pre-action protocol having already been sent, to make and serve a decision by or before 20th March, the agreed date. If you fail in doing so, then we will issue proceedings without further notice. So pre-action protocol letter is sent, and at a point here, point is made that if there is a failure to respond by the date in question, judicial review proceedings would be issued.
Page 101. I've got the
Yes,
request for further information.
yes.
21st Feb. What was your client's response to that?
Okay.
Yes,
I think we see that at the very end, don't we, at page 104.
yes.
104 isn't a response to 101. It's a response to I think 105.
So, thank you. So was there a response to the request?
No, their boss. Yes.
I thought that there was an initial response, no answer, then a chaser, and then a response. Is that's
Yes, I'll just correct. Yes, on 21st of February, Secretary of State writes directly to the appellant. This is the letter that you have at page 101. Despite the fact, and this is the point that is made in the grounds, that there are solicitors who are instructed, who are on the record. The pre-action protocol letter is sent by the solicitors. The response is sent to the solicitors. This correspondence should have been addressed to the solicitors.
Well, I dare say
On-
it could, but it was obviously passed on.
Yes, it was, yes. And 17th is the next email in sequence is one that you have at page 103. And then 104 is the appellant's response saying that I'm not being employed. I do not understand why you're asking this information.
So that was at 2039, obviously responding to the chaser that came out at 1026.
That is correct, yes.
Thank you.
Now, no decision is made by the agreed date of 20th of March.
Agreed in the
The action.
December
Yes.
letter. Yes.
Well, it was an aim in that letter,
Yes,
unlike the letter in the other case.
precisely. So there's a difference in the language that is used, but the aim is to make a decision by 20th. Slightly different from the other case. Yes. So that is the difference. No decision is made by that date, and the appellant issues the judicial review claim the day after, on 21st of March 2025. Now, if you go to the core bundle, the claim is, the claim form starts at page 88. You'll see that the claim is issued page 88 on 21st of March 2025. The Secretary of State makes a decision, and if you go to page 76 of the same bundle, you will see a consent order. And the recitals are slightly different from the other case. The recitals, this is the consent order sealed on 7th of May 2025. The respondent failed to make and serve a decision by 20th of March in line with the action correspondence. The point that Lady Bew made, of course, factually, it's entirely correct, but in my submission, it is mitigated against this particular recital, which you do not have in the consent order in Nisar's case. So both sides agree that the respondent failed to make and serve a decision in line with pre-action correspondence. So, for example, there isn't evidence or a submission that the Secretary of State had aimed to make the decision by that date, but for some special circumstances, she wasn't able to do so.
No.
The claim is settled, and you'll see.
Well, just a minute. You've left out one stage in the story. Upon the respondent serving a decision on the 28th of March, thereby rendering the claim academic. Can you show us the decision?
Well, just like Nisar's case, you do not have that decision in the bundle.
All right.
Yes, it's just that it postdated the judicial review claim. It was obviously not in the judicial review bundle, but that was again a refusal of the application.
Right.
Now, unlike Ms. Mammedov, unlike Ms. Nisar, Mr. Mammedov gives up. He takes the view that the surprise to his girlfriend isn't worth sending
No
another.
longer a
cake.
surprise. I mean,
Yes, it's
I
not.
think he was aiming for her birthday, wasn't he?
Yeah.
Which
So-
is long gone.
Yeah, so he naturally gives up the idea of visiting the girlfriend in the UK and trying to surprise him. So this is the story of Mr. Mammedov.
Yes.
So, subject to any observations, I'll take you now to sort of three key authorities, make some submissions on the law, and will then show you the Upper Tribunal's decision and explain why they got it wrong. Now, lady and lords, you will have, of course, seen from the papers that both sides have referred to various first instance decisions. Now, those decisions are not binding on the court,
No.
and all
Nor
they
are,
should.
nor are PTA decisions in this.
No. All that they show is that there is some inconsistency in the decision-making process in cases like this. And that was the point that was made in the skeleton argument, essentially. But once permission is granted and the court is seized with the appeal, there is little point in the court looking at those first instance decisions. So I'll take you to three authorities that really matter, that the binding authorities of this court, identify the relevant principles, and will then make submissions. So the first authority that I will take you to is M versus Croydon. The court is familiar with it. It's the ultimate authority on costs in cases where there are settlements. Milady, my lords, you have seen this previously on a number of occasions, but I'll have to, I'm afraid, take you to it just to make a few points. If you, lady, my lords, are familiar with the context, these are judicial review proceedings settled by consent. The first principle is one that is identified at the outset, at paragraph 1, by Lord Neuberger. It's page 53 of the bundle. The question of costs is highly fact sensitive and very much a matter for discretion of the first instance tribunal. So highly fact sensitive. And that essentially is the reason why I spent some time on showing you the documents and the facts. The second point that I make is relates to how one judges success in public law proceedings. That is, of course, slightly different from conventional civil proceedings. And the point is made at paragraph 59 of the judgment, page 65. Success in public law proceedings is judged by reference to whether a person has obtained the relief that is sought. It doesn't matter whether a person has succeeded on each and every ground or each and every point that is made. Look at page 65, last paragraph, where a claimant obtains all the relief which he seeks, whether by consent or after a contested hearing, he is undoubtedly the successful party who is entitled to his costs unless there is a good reason to the contrary. So decision maker, the first instance decision maker must decide, in my respective submission, whether the claimant in the judicial review claim has obtained the relief sought. This is sort of reinforced by what is said at paragraph 60 to 63. Again, this is very much a familiar territory for the court. Lord Neuberger says that there are sort of three categories of cases. Category 1 is where the claimant has been wholly successful, and we know that success is judged by reference to whether the claimant has obtained all the relief that he sought. And where there is partial success or where there is a compromise that does not reflect the claim. In category 1 cases, paragraph 61, absent special circumstances, a successful party should recover their costs. So you must decide, therefore, who is the successful party. If the decision maker, the judicial decision maker, fails to make that assessment, that would be an error of law. Second category, and I shall submit that this is a category 1 case. In the second category, if you just look against letter H, in the second category where there is partial success and where there is no clear winner, then again very much would depend on the particular facts. But if it is tolerably clear who would have won, then that would inform the court as to the exercise of discretion. So for example, in this particular case, in these two cases, if the relief sought in the judicial review claim was one, you make a decision within 1 month, and second, a mandatory order requiring the Secretary of State to grant entry clearance to the appellant. And if an appellant had only received relief in the form of a decision, then he could not be considered as wholly successful because he had not received all the relief that he sought. But where the relief is a decision within a particular time frame, and you receive that decision, you receive the relief, then you are the successful party, subject to the issue of causation on which two authorities would assist. In category 3 cases, where there has been a compromise that does not reflect the claim, the default position is no order as to costs. So that is M versus Croydon. The second authority that I will take you to will assist you on the issue of causation. And this is the authority that is cited against the appellants by Miller and Friend. And that is the judgment of this court in ZN Afghanistan. And I will.
So you say in both the Nisar case and the Mammedov case, claimants were wholly successful.
Yes, because they obtained the relief that they sought in the judicial review claim.
So the only relief was give us a decision, even if it's a no.
Yes.
This may be just a semantic point, but the orders made by consent were not orders that granted the relief. They were orders whereby the claim was withdrawn.
Yes.
So it might be said, you haven't obtained any relief.
Yeah.
You got what you wanted, but that may be a different thing.
Yeah. So if, for example, by the date of the consent orders, the Secretary of State had not made a decision, the appellants would not have agreed to those consent orders. They agreed to the consent order because before the consent orders are signed, they got the
So
relief
that
that
raises
was
the
sought.
question of causation.
Causation, yes.
Yeah.
So
That's
they,
where the causation issue.
yeah, so they got the relief that is sought. So Z in Afghanistan is the authority that is cited against me. And when you will look at this authority closely, in my submission, you will conclude that it provides no assistance, none whatsoever, to the Secretary of State.
Sorry, Mr. Miller, can I just catch up? Yes.
So ZN is tab 10 of the authorities bundle. So these are Dublin 3 cases. The Secretary of State made a decision to remove ZN to Bulgaria and certified the claim, the human rights claim, as clearly unfounded on third country grounds. the appellant ZN issues judicial review proceedings. So if you look at paragraph 12 of the judgment, you see that on 31st of March 2015, ZN issues the judicial review claim. Page 148. 14 is the key. The upper tribunal in that case not only refuses the application, but certifies it as totally without merit. So that claim is a hopeless claim, a claim on merits, the claim that cannot succeed on any legitimate view. So hopeless claim, but the appellants argued that despite the fact that the claim was hopeless, they are entitled to their costs. Of course, this case is different. Not only this case is not hopeless for the reasons that I will come to shortly, these were exceptionally strong claims. And then paragraph 15, despite the fact that claims were hopeless, the Secretary of State made an error outside the litigation. The Secretary of State got the maths wrong. Under Dublin 3, as lady and lords may know, there is a window by which the Secretary of State was required to transfer a person to Bulgaria. The window expired on 2nd of March 2016. The Secretary of State got the math wrong and assumed that the transfer window would expire on 2nd of September 2015. On that basis, because of a mathematical error made outside the course of the litigation, you look at paragraph 18, the Secretary of State said that, well, it's now not possible to remove ZN, and therefore he was released from detention. So an error that is made outside the litigation. Now, this is the context in which the court considers whether the appellants should receive their costs for bringing a hopeless claim, which settled because of an error that is made outside the litigation. If you go to page 156, you will see a heading, the appellant's application for costs. And you'll see that the appellants argued that they were successful because they obtained the relief that was sought. And so in real life scenario, they were successful. The respondent, this is paragraph 64, submitted, and this isn't really the submission that is made by the respondent in this case, that she only decided to determine the claim because of the administrative failures on her part, which meant that she was unable to remove the appellants within the time scale under Dublin 3. Paragraph 65, there has to be a causal connection between the merits of the claim and decision or costs. I entirely accept that. So if a claim is hopeless, you don't get costs. That is surely the case. And then the submission is that the appellants have not been successful. And then paragraph 66, the fundamental difficulty for the appellants, Lord Justice Singh says, is that, and these are the words that I invite the court to highlight, there can be no doubt that they would have been dismissed. The claims would have been dismissed.
Yes.
So this is the context in which you'll consider the causation issue. So where the court is in no doubt that the underlying claims are without merit, they cannot succeed, the appellants will not get their costs. But this is not these two cases. This isn't a case where the court can conclude, or the judges below concluded, that there is no doubt that the appellants would have been unsuccessful. Indeed, these two were exceptionally strong cases. You then have the court's conclusion at paragraph 67 that there will normally be a link between the fact that costs have been incurred and the underlying merits of the legal claim. The final paragraph that I'll invite my lady and my lords to bear in mind is paragraph 49, where Lord Justice Singh says, this is the fourth line at paragraph 69, in the present case, there is no criticism which can be made of the respondent's conduct of the litigation itself. The failures of the Secretary of State were outside the context of the litigation. So this is the authority for the proposition that where a claim is hopeless and a compromise is because of the failures, the administrative failures outside the context of the litigation, there would be no causation. The appellant is not entitled to their costs. So reliance on this authority by my learned friend to resist costs, in my respectful submission, is misplaced. The authority does not assist. The final authority that I'll take you to is again, which is one that is cited by my learned friend against the appellants. The judgment of this court in Parveen. You have that judgment behind tab 12 of the authorities bundle. You see the facts in the head note. There's a mother with mobility problems with 6 daughters. She's presented as homeless. She issues a judicial review claim because counsel had failed to secure a suitable accommodation. A month before the hearing, counsel offered accommodation and the judicial review is compromised. If you go to page 192 of the bundle, you'll see a heading, causation. The fact that a person has obtained relief does not mean that the existence of the proceedings has caused or contributed to that result, It may be that it would have happened anyway. Causation is relevant to the exercise of discretion. So no dispute about the principle. Question is whether proceedings have caused or contributed to the result. If you go to the next page, page 193, at paragraph 34, you'll see a reference to the judgment of this court in RL. The authority is in the bundle. I'll not take you to it because this is an accurate summary of what the authority says. If you look at the court, this is the judgment of Sir Rupert Jackson. If you look at the first paragraph, you'll see a reference to M versus Crichton. If you look at the fourth line, and this is the line that I respectfully invite my lords and my lady to highlight, although in broad terms, the relief sought was the provision of accommodation, this is the key, such relief was not available as a matter of law. So in the judicial review claim, the appellant, the claimant, was seeking a remedy that was not available to the claimant as a matter of law. The claimant was ineligible for housing assistance due to their immigration status.
Well, that was what they were aiming at, but in 34 line 3, 2 to 3, we're told, and this is a summary of what happened in RL,
Yes.
the claimants sought an assessment under Section 17 of the Children Act to determine if accommodation could be provided. So that's a different version of what they were claiming.
Yes. Yes. No issue with that.
If that's right, then is there a comparison to be drawn with what your clients are seeking? They want a decision. They obviously want the decision that favours them. But what they're claiming is a decision.
If the appellants are not entitled to a decision by the specified date, then we don't get our costs. I entirely accept that. If the appellants are claiming something that they are not entitled to as a matter of law, they will not get their costs. But this is not that case, because as a matter of law, and I'll come on to that when I'll show you the Upper Tribunal's decision, they were entitled to a decision by the promised date. And this really is the context in which you'll read that paragraph in full, that the fact that assessment was completed did not represent the appellant's success, because they were not entitled to, it would have happened anyway. And then the paragraph 75 is, paragraph 75 of RL is where you have a sort of two-stage test. This is Lord Sandhill. Paragraph 35 of this judgment, where you have that paragraph quoted. And this is a point that my Lord, the Vice President, made when I was making submissions earlier this morning, that the claimants believed that the assessment had been delayed, although we now know that it would be completed within a week. That was something they had no way of knowing. So these appellants had no way of knowing when the proceedings were issued that decisions would be made in a few days' time. And then Lord Sandhill says that I believe that it would be appropriate for them to be awarded their costs. Where, and then you have the two-stage guide, where the court is in a position to decide with sufficient confidence that that Croydon was legally obliged to produce assessment prior to the date in question. So I, of course, need to persuade you that the Secretary of State was obliged to make a decision by the promised date. And the second limb is where it was reasonable for the claimant to issue proceedings on that day. So whether there is an entitlement in law and whether issuing of proceedings was a reasonable step. Well, this is really a two-stage limb that you'll apply. The reason why there was no order as to costs in that case is identified at paragraph 36 on the next page. Approaching the matter in that way did not avail the claimants because they could not readily show that the local authority had been guilty of unlawful delay in completing the assessment. So if I'm unable to persuade you that there was unlawful delay by the Secretary of State in these cases, that is relevant. The judge, and then you'll see a heading proportionality, and paragraph 40, a point is made that liability of costs is ordinarily determined on papers, and it's important to bear the fact in mind that the investigation should not be disproportionate. The judge, the first instance judge in that case, formed the view that it wasn't possible to ascertain whether the proceedings contributed or caused the relief to be granted without a full trial. And for that reason, the judge took the view that no order as to costs is appropriate, and that was the order that was upheld by this court. So on analysis, again, on the facts, this does not assist the Secretary of State. So these are the three authorities that I wanted to take you to. I will not take you to authorities such as FH, the authorities on delay. If my learned friend takes you to those authorities, I'll deal with them in reply. As I said, this isn't a paradigm case where the Secretary of State isn't making a decision, and we are saying that, well, your failure to make a decision is unlawful. Not this case. Now, with this in mind, if I may then make some very brief submissions on the Upper Tribunal's decisions taken in this case, starting with the case of Nisar.
Yes.
So if you look at the court file in Nisar, the Upper Tribunal's decision is at page 70. The Upper Tribunal made no order as to costs. I have a few points to make about this decision. My first point, my lady, my lords, page 70 of the code one. The first point that I make, and this is the first error of law that this judge made, there is no clear decision, indeed any decision, as to who is the successful party. In other words, there is no assessment as to whether the appellant obtained the relief sought in the claim. The Upper Tribunal did not apply M versus Croydon. That, in my submission, is a plain and obvious error of law. The second error that the Upper Tribunal made is at paragraph 4. This is where the Upper Tribunal engages with what appears to me to be an extraordinary submission made by the respondent. She submits, the Secretary of State submits, that the 21st of August deadline was a proposed time frame and not an enforceable undertaking. This may well be the case, the judge says. It wasn't, with respect, merely a proposed time frame, and it is not an option. It is not an option for the Secretary of State to submit that it wasn't an enforceable undertaking. Now, there is ample authority, my lady, my lords, that public authorities are required to deal straightforwardly and consistently with the public. So when a public authority promises to do something, the law requires them to do it unless there is an objective or fair justification of not doing so. If the Secretary of State failed to comply with that promise or assurance, she cannot, with respect, come to court and to say that the promise that I made is not enforceable.
It depends what you mean by enforceable, doesn't it? I mean, of course you couldn't get enforcement by way of contempt.
No,
It's a failure to meet a promise. I thought you were going to say in paragraph 4 that you're quite happy with paragraph 4 and indeed rely on it, but it's paragraph 5 which you're going to say contradicts paragraph 4.
Indeed, Lord, I'll move on, but a point that I feel I can legitimately make is that when the Upper Tribunal said that that may well be the case, the Upper Tribunal erred. The Upper Tribunal should have rejected that submission roundly. I mean, of course, everyone knows the context in which the words enforceable undertaking are used. The appellant isn't suggesting that the Secretary of State has committed contempt of any sort. That the point is that the Secretary of State made a promise and did not abide by it, and the Upper Tribunal should have rejected it. There is no issue, of course, with what is said later. Within that paragraph, paragraph 4, there is, in my respectful submission, failure by the Upper Tribunal to recognize that there were no special circumstances justifying missing the deadline. So for example, if the Secretary of State had made submissions to the Upper Tribunal saying that, well, this is my evidence, I had tasked a decision maker to make a decision by the deadline, the decision maker was unwell that week, I had to give a case to someone else, and that is my justification, but not this case. And then you go to paragraph 5, Lady and Lords. And the first point that I make is that the Upper Tribunal did not attach proper weight to the delay of 1 day. On the other hand, the Upper Tribunal said the respondent missed the deadline only by 1 day. Well, missing a deadline by 1 day is a miss. Miss is a miss. Is as good as a mile. It would have been reasonable, the judge says, for the applicant to contact the Secretary of State. There is no such burden on the applicant, on the appellant. She sent many pre-action letters. In particular, in the last 2 letters, she gave clear notice to the Secretary of State in writing ahead of the deadline, and also served as a reminder. No assessment by the judge as to whether the proceedings caused or contributed to the Secretary of State making a decision. Just picking the words that were used by this court in Perveen and RL. Now, if the Secretary of State's case is that she did not issue the decision because of this claim, and she issued the decision because of some external factor outside the litigation, well, she is required to provide evidence. There is
I
no...
thought the point being taken on the other side is that the judicial review claim, in the sense of the issued document, didn't cause the decision because the decision had already been taken, they're not communicated. And I can see a number of reasons why you might say that was a bad point.
Yes.
But it's not. Isn't it this, Mr. Malik? You say that the decision when it was originally made or drafted was caused not by the issued claim, but by the threat of the claim. Your solicitors were not to know that the decision had been taken in the draft sense on the day that they issued proceedings.
Yes.
But it's what do you say about the judge's assessment of reasonableness?
Well, that yeah, I mean, this simply, with respect to Lord, simply ignores what happened in this case. Ignores the fact that a pre-action letter on delay was sent to the Secretary of State. That resulted in the and with a threat that we will issue judicial review claim on the grounds of delay, making the point that there is a history of unlawful decision making. In response, the Secretary of State agreed to make a decision, confirmed that a decision would be made by 21st of August. That promise was the reason why the claim was not issued at any point prior to 21st of August. The claim is issued on 22nd of August after expiry of that date.
And I suppose you say the judge's paragraph 5 doesn't make any reference to the fact this was the 5th time round. It's different if it had been the first time round.
Absolutely. So absolutely, and this really was the point that I wanted to make as to paragraph 6 of this order, having regard to the conduct of the both sides. Now, this is the appellant did nothing wrong. So there is no objectionable conduct, misconduct by the appellant. Well, on the other hand, the Secretary of State made 4 decisions, more or less on the same terms, placed the appellant in a merry-go-round, failed to comply with the promise, gave no explanation or an update for not meeting the promise, and the appellant's actions were entirely justified.
Right. Anything else to say on Nisar?
Just two additional points. First, no recognition by the Upper Tribunal that the appellant's case was indeed a very strong case. A suggestion, I make that point because my learned friend, at least in writing, submits that the claim was unlikely to succeed.
The appellant's substantive case or
Yes.
case on delay?
Yes. Because my learned friend cites FH and says that, well, a delay is not actionable in public law unless it's witness-free, unreasonable. If my learned friend makes that submission orally, I'll take you to FH. But surely this isn't a case where, this isn't an FH style case. I showed you the pleadings where the appellant said that we are not, isn't a case where there is delay and you're issuing a claim in saying that there is a delay. This is an exceptionally strong case. So, my lord, if for instance you are sitting and deciding the claim on merits today, or when the decision was made, so you will have on one hand a promise by the Secretary of State making a decision, and on the other hand, no evidence or justification for not making the decision. The claim would have succeeded in absence of a justification by the Secretary of State. So no recognition by the judge that it's a very strong case.
Very strong case of unlawful delay.
Unlawful delay, failing to comply with the promise. I mean, of course, I make that point because of what the court had said in ZN. So if a claim is hopeless, that is relevant. Likewise, if a case is very strong, then that is relevant too. The final point, again, a point that my learned friend has made in writing, that the appellant's application was refused again by the Secretary of State. And that refusal demonstrates, if I've understood the case correctly, that the appellant wasn't really a winner. A bad point in my submission for 2 separate reasons. The first is that the relief that was sought in the claim was about the delay only. The submission was that the Secretary of State should make a decision, yes or no, by the deadline. Second point is one that I made, that the remade decision was a poor decision again. The Secretary of State decided to withdraw that decision and granted entry clearance. So these are my submissions on Nisar. It's taking you then to the decision of the Upper Tribunal in Mammedov. Mammedov, the decision of the Upper Tribunal in Mammedov is page 60 of the bundle. Sorry, page 55 of the bundle, my apologies. So, unlike the judge in Nisar case, this judge applies M versus Croydon, and at paragraph 8, the judge correctly concludes that the appellant is the successful party. The appellant obtained the relief sought in the claim, namely a decision, and therefore the appellant is a successful party. Now, M versus Croydon says that in those circumstances, the successful applicant is undoubtedly is the word the Lord Neuberger used, is undoubtedly entitled to their costs unless there is a good reason not to make the order. The judge says that there is a good reason to depart from the norm, and the good reason is failure to comply with the pre-action protocol. In my respectful submission, there was no such failure. I have taken you through all pre-action protocol letters. There were, of course, you'll consider the final pre-action letter in the context that that was the third letter that was sent. There was no obligation on the appellant to send another pre-action protocol letter before issuing the claim. The appellant did not issue the claim earlier because the Secretary of State said that she aimed to make a decision by the date in question. She then provided no update to the appellant, did not make a decision by that date, and he was perfectly entitled to go to the Upper Tribunal without any further notice. He did nothing wrong. But even if, my lord, my lady, my lords, you take the view that a further notice was necessary, he did send that further notice. This was the last letter, the reminder letter that I showed you in the chronology.
The Sunday afternoon, 16th of March.
16th of March, yes, reminding the Secretary of State that you had agreed to make a decision by 20th of March. If you don't do so, we will issue the claim. So there's no obligation on the appellant to do anything further. In my submission, the judge fails to recognize the significance of that email. You've seen that email. It was very clear, a clear notice. It was succinct, of course, but the reason why it was succinct is because both sides knew what the background of the case was. Both sides knew what the earlier pre-action protocol letters had said. There isn't an assessment by the judge as to the issue of causation, whether the claim caused or contributed to the Secretary of State making the decision. I make the same point again, that if the Secretary of State's case is that she did not issue the decision because of this claim, or because of the threat of the claim, and she did it for some external reason, as was the case in as was the case in ZN, then it is for her to provide that evidence, make that submission. There's no evidence, no submission that there were exceptional external factors why the decision was made. Like Nisar case, I do submit that this was also a very strong case on merits, in absence of the Secretary of State's justification or evidence. The fact that visit visa application was refused again is not relevant. It does not undermine any of the submissions that I've made. And the final point, my lords, my lady, is that even if you take the view that, well, these are all bad points and the appellants should have sent another pre-action protocol letter, what I do invite you to consider is whether failure to send a pre-action protocol letter justifies making no order as to costs. Not this case, but in another case where there is a failure to comply with pre-action protocol, that would justify justify a reduction in costs entitlement. But even if you take the view that there was a duty to send another pre-action protocol letter, that in my submission did not justify making no order as to costs. So I do invite Lady and Lords for these reasons to set aside the decisions made in both cases and to substitute decisions requiring the Secretary of State to pay the appellant's reasonable costs. Very grateful for your patience. Unless I can assist you any further, these are my questions.
Thank you very much, Mr. Alec. Mr. Gajar? Yes, Mr. Brown.
My lady, my lords, let's start with, just very briefly, with the issue of the merits of the entry clearance officer's decisions. The issue of merits in my submission isn't one of the issues before this court, but rather the issue of the timing of the decisions. So far as my learned friends rely on the Secretary of State's agreement to reconsider decisions, each of those were the product of agreement, mostly by way of pre-action conduct. In one prior case in Miss Nisar's claim by way of a consent order after judicial review proceedings had been started. And for those reasons, I don't want to spend too long on the question of merits. But in light of one of the particular points that was addressed in the course of argument, was the subject of the question, I have wanted to go to, in Mr. Mammedov's case, the approach that the entry clearance officer took to the explanation Mr. Mammedov had given as to the reasons for his visit and the quality of the evidence that accompanied his application. At page 61 is a copy of the reasons for the first refusal.
Core or supplementary?
I do apologise, in the supplementary. And there, under the heading "The Decision," 3 paragraphs down, the entry clearance officer says, you state that you will visit your girlfriend in the United Kingdom for 10 days. You state that you wish to surprise her and provided a letter from her flatmate. However, the information you provided in support does not demonstrate your girlfriend's legal status or her circumstances in the UK, which leads the entry clearance officer to doubt the credibility of the application. So the entry clearance officer draws a distinction between evidence from the girlfriend and evidence in relation to the girlfriend, which in my submission didn't reflect the particular grounds of challenge that Mr. Mammedov pursued in the pre-action correspondence in respect of the entry clearance officer's approach. And the court saw that in the same bundle at page 68, paragraph 6. Wasn't planning to go back to that. So as I say, what I hadn't prepared to do and don't want to spend time doing is going through the differences between the parties as to the merits of the applications and the reasons for refusal. But that in my submission is one example of why the submission that these were poor quality decisions certainly isn't one that the Secretary of State accepts. The decisions, unusually, in light of the prior authorities here, notably, are decisions in effect to refuse the substance of what each of the appellants must have been seeking, which was permission to come to the United Kingdom as visitors, and the history of the proceedings leading up to the 2 judicial review claims with which this court is concerned, do not, in the case of either appellant, result in a grant of entry clearance by an entry clearance officer. And as my learned friends have said, it's only in relation to Ms. Nisar that there was subsequently a grant of entry clearance sometime after the cost decision in this case.
But I think it's nonetheless accepted, isn't it, on your side, that for M and Croydon purposes, in each case the claimant was a successful party.
My lord, yes, but I'll come to another authority which this court hasn't so far been taken to, which in my submission qualifies the status of M. Croydon. Again, my learned friend has already taken the court to authorities which qualify the status of M. Croydon. That is, the court is not concerned solely with an inquiry whether the claimants have achieved the success which they sought after issuing proceedings, because there may be reasons other than the underlying legal merits of the claim or the fact of issuing proceedings which lead to the result which has been sought in the proceedings. And that, for example, is the kind of situation seen in the decision in ZN, the decision of Lord Justice Singh, which Mr. Malik took the court to, and I'll take the court to a fairly recent decision of the Upper Tribunal, which is part of that line of authorities.
Right.
I'd wanted also just to identify the periods between each of the applications and the decisions in question, because although a lot has been made of a 3-month time window, in fact only 2 decisions in respect of all of those taken in relation to Mrs. Nisar and Mr. Mammedov approached that time window. So the first application by the Nisar family, made on the 8th of June 2022, refused on the 29th of August 2022, took therefore 82 days to be decided. That's 11 weeks, slightly short of 3 months. Each of the following decisions that were taken in relation to the Nisar family, so the following 4 decisions, took between 45 and 49 days, so not more than 7 weeks, and substantially less than 3 months, including the ultimate decision so far as this appeal is concerned, that taken on the 28th of August, which took 48 days. And in relation to Mr. Mammedov, the first decision on the original application took 3 weeks. The second decision took 4 weeks. And it was only the third decision which took a total of 95 days, very slightly longer than 13 weeks or 3 months.
Is it relevant to look at the overall total of time? Because the Nisar case, if you add all those things up and comes to a lot more. Take your point about the merits, but overall there was a long period of time as a background to the final motion complaint.
My lord, there are a number of associated relevant considerations if that were to be the approach in either case. For example, in Mr. Mammedov's case, a very long time passed between the 18th of September decision and the pre-action protocol that was sent by him, I think on the 7th of November. So it was 7 weeks between receipt of the decision from the entry clearance officer and the pre-action protocol in Mr. Mammedov's case. So one of the relevant considerations in my submission is, as it were, then the totality of the time period and who was doing what at any time. A further consideration is why does delay matter? We know that Mr. Mammedov's original application was so that he could see his claim was that he wanted to visit his girlfriend for her birthday. Her birthday, he said, was on the 18th of October 2024. Having received the 18th of September 2024 refusal, 3 weeks after his application was made, he didn't then send pre-action correspondence, as I've said, until the 7th of November. In fact, the Secretary of State responded within a week to that pre-action correspondence, but of course by then Mr. Mammedov's girlfriend's birthday had passed, and the later period between the 20th of December and the 25th of March 2025 then coincided with what Mr. Mammedov had said in his application was his commencement of an internship in Turkey, which would mean that he couldn't travel to the United Kingdom. So, and again, I make an overarching submission that what we see from the other decisions of the courts, for example, Parveen and R.L. Croydon, are judicial reviews concerning families in the United Kingdom who are concerned about housing, and other decisions that have been referred to in arguments, for example, concern asylum applicants who are in the United Kingdom and who are seeking decisions because until they have a decision on their application, they are not able to work, they're not able to invite family to join them in the United Kingdom and so on. And so one of the matters which appears to be essentially unexplained factually is what was the state of urgency in either Mrs. Nisar's case or Mr. Mammedov's case that required them to start their judicial review proceedings quite so quickly after the dates that they relied on, given the overall history of events up to that point.
Well, is that a general submission that in an ordinary entry clearance case it doesn't matter?
In my submission is relevant certainly to questions of success and relevant to, it may for example be relevant to the grounds on which a party seeks judicial review of delay by the entry clearance officer. But what neither of these cases concern, as so many of the other cases before this court have, is acute circumstances of need or distress, which until resolved are leaving claimants in a perilous or difficult situation. By contrast, these were foreign nationals seeking to come to the United Kingdom to visit, and therefore in very different circumstances to many of the claimants and appellants whose cases have been considered in this context. I'd wanted to address one factual matter in the course of my learned friend's submissions, which was the suggestion that in Ms. Nisar's case, the Upper Tribunal had taken into account in making no order as to costs the absence of a pre-action protocol letter from Ms. Nisar. That wasn't the case in relation to Ms. Nisar. It was the essence of the Upper Tribunal's decision to make no order as to costs in Mr. Mammedov's case, but that's not something that appears on the face of the Upper Tribunal's decisions in relation to Ms. Nisar. With those preliminary observations over, could I then turn to the authorities which so far haven't been addressed? The first of those is behind tab 14 in the authorities bundle, a relatively recent decision of the Upper Tribunal on the question of costs. At page 222 of the authorities bundle, paragraph 19, the members of the Upper Tribunal, Mr. Justice Swift and Upper Tribunal Smith said, applying the same rules as would apply under the civil procedure rules. The general rule is that the unsuccessful party will be ordered to pay the costs of the successful party in lawyer shorthand costs as set to follow the events, with the events being the outcome of the trial. In different ways, each of the cases we have been referred to has wrestled with how to apply that general rule in circumstances where proceedings have been issued but have come to an end before trial. The authorities have been clear that in such circumstances the general rule still applies, but how to apply that rule is more difficult because the decision must be made even though the relevant event has not occurred. In different ways, the approaches advanced in the judgments each indicate circumstances which might provide suitable proxies for the outcome of the trial or point as to how the general rule would have applied after trial, subject always to the proviso that whatever exercise the court undertakes to decide a cost application made in these circumstances should be a proportionate exercise. When considering the application of the approaches referred to in these judgments, it is important to have in mind the need to decide such cost applications can arise in a range of different circumstances. To take obvious examples, for judicial review claims, applications made because a trial is no longer necessary may arise shortly after proceedings have been issued, after a decision to grant permission to apply for judicial review or at the door of the court. The information available to the tribunal required to decide the cost application will always fall short of the information that would have been available had the proceedings gone to trial. But what is available to the tribunal from case to case may vary significantly, depending on when the need to make the application arises. This means that the approaches set out in the authorities must be applied in ways that reflect the circumstances before the court, rather than merely slavishly. At paragraph 21, the Upper Tribunal turns to the question of what M and Croydon was authority for, and at the bottom of page 223 of the authorities bundle, the tribunal said, "We have no doubt that in setting out his three categories, those are the three categories to which my learned friend Mr. Malek referred, and which I know this court will be very familiar with, Lord Neuberger intended to do no more than, by reference to three broadly defined classes, provide guidance on how the general rule might apply where a costs application is made in circumstances where a trial is no longer required. He did not intend anything approaching prescription or codification." And rejecting the submission as Lord Justice Singh had done in ZN, that in light of M and Croydon, there was no need to inquire beyond the question whether the relief sought had been secured. The Upper Tribunal said at paragraph 26, if the issue for the tribunal is whether the case before it falls into Lord Neuberg's category 1, such that on the application of the general rule, the defendant should pay the applicant's costs, the tribunal must have in mind the rationale for the costs follow the event rule. The Upper Tribunal then cited the passage from Lord Justice Singh's judgment in ZN that this court has been taken to by Mr. Malek, and went on a conclusion that a case falls into Lord Neuberger's category 1 is a conclusion that the causal link referred to by Lord Justice Singh exists. When deciding whether that causal link does exist in any particular case, a tribunal ought to take into account such information as is relevant and is available to it at the time the decision falls to be made. So in my submission, another authority which invites a court, so far as is proportionate, to go beyond merely inquiring into whether the relief which has been sought has been obtained. Lastly, and again, the court was taken to this by Mr. Malek, but I just wanted to revisit the whole of the passage in context. May I take the court to RL, which is behind tab 8 in the authorities bundle. The facts reading from the headnote were that the claimants, who were a mother and her 3 children from Ghana, had informed the local authority that they faced eviction, pausing there. And another of the cases which, in my submission, identifies the common underlying factual circumstance, distress, and a degree of urgency. And since the mother was ineligible for assistance under the relevant homelessness legislation because of her immigration status, the local authority began an assessment under Section 17 of the Children Act. Nearly 2 weeks after they had been evicted, the claimant sought judicial review of the failure to provide accommodation under Section 17, and a week later the assessment was completed, which recommended temporary accommodation. The claim for judicial review had been refused by Mr. Justice Khan on the papers as not properly arguable, and there was a application for oral renewal for permission to proceed, but prior to the hearing of that, the claim was withdrawn by consent as a result of the provision of accommodation. The judge made no order as to costs, rejecting the claimant's submission that they had been the successful party, notwithstanding that they had achieved what they had sought to achieve through the claim on the basis that Mr. Justice Khan had refused permission in the papers. There were essentially 2 strands of reasoning by the judges in this court. The judgment of Lord Justice Underhill was the subject of Sir Rupert Jackson's agreement. The agreement of Sir Rupert Jackson for this court's note at page 105 of the authorities bundle. The relevant part of the short judgment of Lord Justice Underhill, the judgment starts at 103, is at 104. The reason that I refer to this is because of its relevance to judicial reviews concerning delay in decision making. At letter B, Lord Justice Underhill said, the object of the proceedings was not to secure an assessment, but to secure it sooner than it was feared would otherwise be the case. And pausing there, in my submission, that is the same as applies to the appellants in the case before this court. That being so, the fact that the assessment was in fact completed and that the claimants were accommodated accordingly does not represent success. That would have happened anyway. Again, in my submission, that would have applied to each of the applicants in the appeals before this court. I thus agree with Lord Justice Moylan that the outcome was not the result of the proceedings. In a case of this kind, the measure of success has to be whether, as a result of the proceedings being brought, the assessment was completed substantially sooner than it otherwise would have been. And again, pausing there, I note the use of the word substantially sooner rather than sooner to any degree. I can see no reason for supposing that to have been the case here, and indeed, given the timescales, it seems very unlikely. Accordingly, I do not think it would be fair to award the claimants their costs simply on the basis that they were the successful party. However, I do not think that that is the end of the matter. It is necessary to look at the particular circumstances of the case. The claimants believed that the assessment had already been unlawfully delayed, and although we now know that it would be completed within the week, that was something they had no way of knowing. Again, pausing there, that's certainly, so far as the coincidence of events occurred, the case in Mrs. Nisar's appeal. And that being so, I believe that it would be appropriate for them to be awarded their costs if the court were in a position to decide with sufficient confidence both that Croydon had been legally obliged to produce the assessment prior to the 28th of October 2015, and that it was reasonable of the claimants to issue the proceedings on that date. I say with sufficient confidence because it would not be proportionate to hold the equivalent of a full trial simply in order to determine liability for costs. The court has to do its best to reach a fair conclusion on a summary basis with the fallback of making no order if that is not possible. And my lady, my lords, in my submission, although the Upper Tribunal judges were not taken to RL and Croydon, in my submission, that is the proper approach to an assessment of costs where the basis of a claim is delay. In other words,
two questions which arise. First of all, is it relevant that in the Nisar case, this was the 5th round?
my lord, in my submission, in light of the relief that was sought, it is not a relevant consideration. It would have been open to Mrs. Nisar to seek as the relief sought at a pre-action stage the making of a positive decision in her favour. Equally, the circumstances as they were before the Upper Tribunal judge to adopt but not endorse the description of it previously today didn't end the so-called merry-go-round. It was another refusal of the application for entry clearance, which, as we now know, simply led to yet a further challenge, which led some way down the line to an ultimately successful application. So had this been a situation in which there had been a grant of entry clearance, that might have been a relevant consideration, although I don't accept it on the facts it would have been. But the fact that this simply continued the so-called merry-go-round, in my submission, if anything, tended to reinforce a view that there had been an absence of success for Mrs. Nisar, not success for her.
And second question, and this doesn't depend on it being the 5th time, but you say that the effect of RL and Croydon is a claim for judicial review based on unlawful delay can only succeed if the unlawful delay is substantial.
The authorities put it differently, and I've referred to these in my skeleton argument. This court in AL and Albania, I needn't turn it up unless that would assist the court, but it's behind tab 11 in the authorities bundle. And Lady Justice Arden said, paragraph 32.
I would have a look.
Okay, so it's tab 11,
yeah.
Page 185 is the relevant part of the judgment. And there, paragraph 32, and again, this was in the context of a consideration of a claimed delay relating to an asylum claim. Counsel for the appellant, paragraph 32, had submitted that as a matter of law, the Secretary of State had to make a decision within a reasonable period. And Lady Justice Arden said, even so, her actions are not judicially reviewable unless she acted irrationally in taking as long as she did. So that was the test that was applied by the court in AL Albania. And more recently, in the Queen on the application of Ulla and the Secretary of State for the Home Department, which is at tab 13,
sorry.
So my lord, that's tab 13, Ulla, at page 210 in the authorities bundle, paragraph 62. Lady Justice Elizabeth Lang said the second assumption is that the delay between a date which is a reasonable time after the 20th of May 2019 and the 29th of August 2019, that was a period of time during which the Secretary of State had been considering additional information, was unlawful. Mr. Burrett acknowledged that there was no authority.
Sorry, I'm
So- I'm so
staying
sorry, my
catching
lord.
up. Which paragraph?
Page 210, paragraph 62. Addressing the relevance or claimed relevance of delay, Lady Justice Elizabeth Lang said the second assumption is that the delay between a date which is a reasonable time after the 20th of May 2019 and the 29th of August 2019 was unlawful. Mr. Burrett acknowledged that there was no authority which showed that such a relatively short period of delay, notably that is a delay very slightly over 3 months, was unlawful. He also acknowledged that nothing in the guidance supported his argument, except Mr. Harland's 2 submissions about the authorities on administrative delay. They show first that the purpose of judicial review is not to correct inefficiency or maladministration, but to correct unlawfulness, and second that the delay is only unlawful if it is so excessive as to be regarded as manifestly unreasonable. And her ladyship approved the reasoning of Mr. Justice Collins in RF, which was to the same effect. So in Ulla, the test is whether delay is unlawful, and to be so, it must be so excessive as to be regarded as manifestly unreasonable. So those in my submission are prior decisions of this court setting out in each the essential reasoning as to the circumstances in which delay becomes unlawful.
So is the submission that the outcome of these claims, or what happened subsequent to the issue of proceedings or the claim in the pre-action letter, doesn't demonstrate that there was delay that meets these criteria? All it is a decision.
Yes, applying Lord Justice Underhill's reasoning, there was always going to be a decision from the Secretary of State because there was an outstanding decision which failed to be taken. There was in each case a coincidence of some sort between the taking and communication of the decision and the commencement of judicial review proceedings.
But the submission that's being advanced to us, as I understand it, is that there was delay that meets those criteria. As a matter of fact, either because it was so long as to meet the manifestly unreasonable criterion, or because it was a breach of an express promise to hit a specific deadline.
Yes, what I had been going to do was to go to the grounds of review in Mrs. Nisar's claim, because there, as I understood the submission advanced for Mrs. Nisar, it was that the essence of her claim for judicial review was that there had been a breach of the promise to provide a decision by the 20th of August, or 21st of August. The grounds of review start in the core bundle in Mrs. Nisar's appeal at page 113.
Sorry, what page?
My lady, page 113. And although in my learned friend's submissions, he didn't address the relevance of FH and others, that is the decision which Lady Justice Lang in Ulla, that is the first matter addressed in the grounds under the heading unreasonable delay in making and serving a decision. So the first matter particularised under the grounds of review is that there had been an unlawful delay.
Sorry, page.
It's in the core bundle in Nisar 113.
Letter from the. Oh, sorry. Yes, sorry, my fault. Page 113.
Page 113 in the core
Paragraph
bundle.
24.
Paragraph 24. So far from the grounds leading with a claimed breach of promise by the Secretary of State, they led with a ground that the test set out by, confirmed by Lady Justice Elizabeth Lang in this court in Ulla, so excessive as to be regarded as manifestly unreasonable, applied. And the FH judicial review claims had concerned claimants for asylum, some of whom have been waiting very considerable periods of time indeed for their claims for asylum to be determined, during which time they couldn't leave the United Kingdom, they couldn't work, they couldn't receive visits from family members overseas. The next authority which is cited in the grounds on the following page at paragraph 25 is again on the issue of delay and concerns the question of the duty to deal with matters in a reasonable time. So again, the second matter is not one leading with an alleged breach of promise by the Secretary of State in the course of extensive correspondence. Similarly, paragraphs 26 and 27, paragraph 28 and its subparagraphs on page 116 are again concerned, or at least the heading seeks to identify principles which distinguish the appellant's case from an FH-style delay complaint. It is, again, here that various matters relating to the totality of the period are set out in relation to the appellant. But of course, the totality of the period have been the product not of matters of the Secretary of State's own making, but as a result of a bipartite process of decision-making, challenge, concession, and reconsideration. In circumstances where it was always open to the appellants simply to maintain, if they wish to do so, a claim for judicial review or a claim for judicial review on a different basis. And I'll take the court, I anticipate, after the adjournment to attention in the way that Mr. Mammedov's pre-action correspondence was expressed in relation to what was actually being sought.
Well, just sticking to Nisar for the
Yes.
moment, would it be better or worse for your case if the first PAP letter had been met with a response on the lines of, we're so overwhelmed with work that it would take at least a year to reply to your application to come to this country, yours faithfully?
Well, it might depend on the ground of challenge, and it might depend on the broader circumstances. If the circumstances were a claim to visit the United Kingdom for something that was acutely time critical, and the application were a very straightforward one, then there might be grounds on which a challenge could be maintained as a result of a response saying it's going to take a year to deal with a visa visa application. but if the question was breach of a promise, it plainly wouldn't avail an applicant to allege a breach of promise if it was clear that there hadn't been a breach of such a promise as a result of what the Secretary of State had said.
All right, just give us a preview of what ground you still have to cover.
I was going to finish dealing with the way that Mrs. Nisar's grounds of judicial review were expressed. I was then going to deal briefly with similar factual matters in relation to Mr. Mammedov, and then I was going to make my brief submissions about why I submit the Upper Tribunal's decisions were each a lawful exercise by the judges of their discretion.
Right, and can you give a time estimate? It depends how talkative we are, I appreciate that, but
if I were allowed up to 45 minutes, I would try to finish within that time, my lord.
right. 2 o'clock then?
All rise if able.